The Profiles in Leadership series offers an unparalleled opportunity to glean insights from top leaders who serve in government, education, the private sector, and civil society. In each episode, we invite these leaders to reflect on their journey and share skills, core values, and qualities that make them the leaders they are today. I'm very pleased to welcome James Grimmelmann. James is the Tesla Family Professor of Digital and Information Law at Cornell Tech and Cornell Law School. He studies how laws regulating software affect freedom, wealth, and power. He helps lawyers and technologists understand each other, applying ideas from computer science to problems in law and vice versa. He is the author of the casebook Internet Law, Cases and Problems, and of over 50 scholarly articles and essays on digital copyright, content moderation, search engine regulation, online governance, privacy on social networks, and other topics in computer and internet law. He has been blogging since 2000 at the Laboratorium. His homepage is at james.grimmelmann.net, and we'll include links to both of these in our video description below. So, first of all, welcome, James.
Thank you for having me. It's great to be here.
Tell us about the Laboratorium. How did it come about? What were your goals? If there were any obstacles, and its longevity?
Yeah.
Spill the beans.
In early 2000, I noticed that one of my friends had started blogging informally, and it just seemed really appealing to me. I'd had conversations with people online for years, we'd been on Usenet and discussion lists, but the individual but public nature of blogging really appealed to me. It felt like a really nice medium for the kinds of conversations and discussion that I enjoy and want to see more of in the world. And so I created the lab on an account at my local ISP and started just posting to it without any plan in mind. I was writing initially in HTML and then in a very hacky XML to HTML translator. And I just started posting about whatever struck my interest. I was working as a programmer at the time. This predated law school. So it was about local news or movies that I saw at film festivals, occasionally about funny things I'd seen around town. And it's been a presence in my life ever since. It's taken on maybe a bit more of a professional role now that I write publicly, but it's still, to me, very much like just the dream of Web 1.0 blogging. Has been something I've carried with me for 2.5 decades.
And do you have a sense of what your audience is?
I have no sense at all. I don't have comments. I don't have analytics. I literally do not know who reads it.
Now, this is by design?
Yeah, I decided at some point in the rise of social media in the 2000s, late 2000s, that I didn't want to be driven by analytics. I really did not. I saw what the desire for audience and virality does to people. And I decided that I was just going to write without worrying about that. And the best way to not worry is to not know.
So this is pure and unfiltered James Grimmelmann.
It's not unfiltered. I have a pretty high threshold now for what I put there, because for casual conversations, that's what group texts or Mastodon are for. So I generally try to make the things I post there pretty polished, but it's my voice and it's not on behalf of anyone else.
Yeah, that's what I meant by unfiltered. And talking about chats, I also want to talk about some of the more recent things you have posted, because you have been having chats with ChatGPT.
So I've been having chats with ChatGPT, but they're very, very specific.
You talk about chess, you talk about Charles Dickens. How do you pick your topics?
I didn't pick them. I'm asking ChatGPT the questions verbatim from Turing's paper on the Turing test. And so I'm very eager to see how this round of AIs responds to the questions that were supposed to be representative of the kind of questions that would distinguish human from artificial intelligence.
And what do you think so far of their responses?
It's fascinating because the answers to the math problems are correct, of course. The poetry is not good, but it is metrical and on topic. The discussion of Dickens is perfectly adequate. It's like the kind of exactly in the heartland of what people do. And then shockingly, it plays chess really badly.
Interesting. Yeah, it is shocking because you think about AI, the first thing you think about is how they're beating humans at chess left, right, and center. Oh,
Yeah,
so why do you think that is?
it's because ChatGPT is a language model. And if you give it a chess problem in words, it does not have enough of a representation of the underlying chess position to recognize what everything is. If I gave it algebraic notation for where the pieces were or the game to that point, it might well complete that because the position Turing gave was a standard king and rook mate. But we just rephrase it a little bit and the language patterns don't match.
So is your answer to the Turing test, it depends?
So I don't think you can ever get a good answer out of doing what I'm doing. This isn't a joke and an experiment. The point of the Turing test is it's interactive. The interactivity and unpredictability of what we ask about means that you can't just have a huge library of canned answers because a good questioner could exhaust a pre-written library. And so I'm never going to get at that by just asking it, the kind of questions that have been famous for 50 years.
So the other thing that you do is your casebook, Internet Law. Is ChatGPT at some point going to be a feature in it, whether as a subject of it or as a co-contributor?
So it's definitely going to be a subject. The lawyers who filed fake cases because ChatGPT made them up, they are going in the next edition. It's a perfect entry point into talking about what generative AI is and what it does and how it works. I'm hoping that the opinion will be good because I'm counting on it to cover this material. And I'm also reassessing what else in the book needs to change to cover generative AI. We don't have cases on a lot of the issues, but I can see this touching many, many parts of the book.
Tell us about the backstory behind this book.
So I started teaching internet law 16 years ago. And at first I taught out of existing casebooks that were quite good. But what happened is it would go a couple of years and the book would slip out of date because so much was happening. So I found that I had a casebook, plus I had a stack, this high of supplemental materials. And at some point, I realized the supplemental materials were larger than the casebook. So I flipped over, and I taught for a bit using my materials as just like, here, read this passage, read these cases that I've edited for you for class. And after a bit of that, I talked to Lydia Lauren and Joe Miller, who run Semaphore Press, which is a online low-cost publisher of casebooks. And we said, yeah, this would be a great casebook on its own. So I worked the materials up into an actual casebook. And then every year since then, I have edited and added to it. And it has evolved with the years to cover new things, but it's basically a living attempt to provide a good textbook on internet law.
And we are talking about leadership, and we shouldn't lose sight of the fact that when you started doing this, most law professors would be thinking of West, or they would be thinking about Aspen. Very few, if any, would be thinking of the Semaphore Press model that you embarked on. And now everybody seems to be on that bandwagon. So you led the charge. What do you think happened that got more people on this side of the equation?
So in large measure, this is a story about the collective success. of people in the IP and tech law community in living out their principles. That it's not a coincidence that Lydia and Joe, who created Semaphore Press, teach IP. And they thought about what restrictions on distribution of knowledge do for people and for society. So a lot of other moves in this direction have come out of this community because we talk about openness and open access a lot in other settings. And so we've got a remarkably good set of materials across all of the subjects in our field. You have the authors of Intellectual Property in the New Technological Age, which was an Aspen casebook, took back their copyright and self-published because they decided Aspen was charging too much. And you have other authors who have just built their casebooks from scratch because they wanted something that was more open, more affordable. And what has really happened in the last 5 years is this success within IP and tech has spread throughout the academy. You now have good open casebooks that are kept pretty current by faculty, covering not quite all of the curriculum yet, but a lot of it. And I just think the sort of collective response by the academy to the outrageous prices charged by the commercial publishers has been exactly right. Just we'll make our own alternative that's a better proposition for everyone.
So do you think we have reached a tipping point? This is the new normal, and we expect cheaper, more accessible casebooks going forward?
I expect so. I think that we're going to see the first casebook in the areas we don't have them for within a few years. And at that point, it's really just going to be getting professors, one faculty member at a time, to switch because they see the benefits of this model.
So 10th edition, it's been a long journey and definitely not just a bed of roses. So tell us what were some of the challenges you faced along the way and how you got to this point.
So one of the challenges has been that I knew some areas much better than others when I started. So the initial casebook had a very detailed coverage of copyright because that's one of my research subjects, and I felt confident in what I could do there. There were other areas like privacy where I knew the range of issues much less well. And so I had to, over time, build out those sections better. I would honestly say the last couple of editions are the first few where I think I've actually had something useful to say about consumer privacy. I just wasn't covering that subject in a unified way before, and it just takes a lot of time teaching and reading to get the sense of everything. The other thing that's really been whipsawing me over the years is trying to figure out how much to chase after important recent developments. So after the Edward Snowden revelations, it seemed like national security surveillance was a major topic in internet and privacy law. And so I couldn't responsibly not cover it. I'd say the same thing seemed true about network neutrality during the back and forths of the 2010s. Just it was a subject people were talking about a lot and the book would have to cover it. Both of those areas have resulted in much less law that's of broad internet law applicability than I expected. So I've spent a lot of time writing very large, explainer chapters that wind up not being that relevant because there's just not much happening there. So the balance between how much do I have to add to keep up with things versus what's a distraction has never been an easy one to strike.
Well, there's also that word that you use several times, time. How do you find the time? You are a busy law professor, you have your own family, and all these other things, and it takes a tremendous amount of time. So how do you do it?
I'm never not thinking about the casebook. And I honestly read cases always with one eye towards whether I need to excerpt them or cite them in the book. So during the year, just in the course of my ordinary reading, I always have a database of things that I want to add or consider adding to the book. And I don't make those calls during the year. I just find a case or find a story, and I make myself notes about maybe I should discuss this. And then over the summer, every summer, I sit down and I take about 2 weeks to go through all of those notes and just decide what has to be in, what has to change for the next edition. That's also when I roll up all of the typos that I and others have spotted, any mistakes that I need to correct. And so it's a lot of time collectively over the years, but it's not that big a distraction from the work that I'm already doing just because this is one of the classes that I teach.
Yeah, it's a nice contrast to your blog, the Laboratorium, where you get no feedback. In this case, you actually, and I encourage our listeners to go on James's website to read his very witty invitations for feedback. How much feedback have you gotten over the years, from who, and tell us about some of the types of feedback that you get.
I get really lovely and really helpful feedback from a lot of people. Sometimes there are students who will say, I liked using your book, and here are all of the typos that I noticed while reading through it. And these are law students. They have great attention to detail. So here's been an email with 15 typos that they're all obviously correct. So I just need to make those changes. In other cases, I have people who tell me what they did in their courses. They'll say, well, I used your book, but my book has a bit more of a cybercrime focus, so I supplemented it with this. Or they will say, I enjoyed teaching this chapter, but I found I wanted to give them this, and your book didn't have that. Do you have any suggestions? And sometimes I will just have a suggestion and send it off. But other times they're like, no, actually, this belongs in the book itself. And so their suggestions on what they've added or what they would like to see are really helpful in making sure the book serves their needs.
Do you ever get hate mail?
Nothing. Not about this.
Politicians should line up and take this as a masterclass. How do you get feedback without getting hate mail?
I'm mostly keeping my head down. There are certainly things that are controversial that I'll get yelled at on social media for, but the casebook is a very small, pretty nice community. You have to sort of be looking for it to even find the website, and I just email everybody who's adopted the book with an annual update when there's a new edition available, and then I sort of invite them, give me your feedback. The list of people who've chosen to teach from the book is not a group of people who are going to come flame at me about it.
Have you considered getting some of them to be collaborators on the book?
I've thought about it from time to time. There are a lot of people who I really admire who have used it at one time or another. It's really a matter of the book has a very particular editorial philosophy, and it's very much reflecting my vision and voice. So if I want to meet somebody who I think is really exactly on that same wavelength, then I would be interested in bringing them aboard. But part of what I like about it is like everybody who teaches it comes from a slightly different place. So I can admire what somebody has done with using the book in their course and find it really interesting without thinking that the book itself should look like that. I collaborate with people on other projects, and every single one of them has a different mix of our personalities and styles.
So let's talk about blockchain and poop. You did a video about it in a very short and succinct way, explaining blockchain and smart contracts, and use poop as an analogy, which I'm sure immediately grabbed your audience's attention. Tell us a bit about that type of approach in helping lawyers and technologists understand each other and sort of making some of these more arcane concepts mainstream.
So one thing that I'm constantly doing is looking at how people explain things. And I look for good examples of exposition in law and good examples in technology. And so I'm always always in my blogging, my scholarship, my teaching, trying to think of what is the minimal, simplest way to explain a concept. And one of the things that I've really learned is that vivid examples are incredibly important. That you want to have like either vivid metaphors people would hang on to, or specific examples that raise the issues you want to and carry things through in a really clear way.
What are some of your favorite ones?
So I gave a lecture today about blockchain, and I wanted to talk about NFTs and how you can tether them to tangible assets. And the tungsten cube is a perfect example for that, because if I want to say that this NFT on this blockchain controls who owns the physical rights in this 12-inch tungsten cube in a warehouse, the tungsten cube is a really easy, vivid thing to wrap your head around. You can talk about where it is, how much it weighs, how hard it is to move, and people will remember the tungsten cube. That's a really easy example to hold on to. I try to pick cases in my case book when I teach in class for similar. I want something really vivid. And that's part of why I really like the ChatGPT lawyer story. It's so routine in some ways, but so specific in others that actually saying, okay, no, this is a dispute about an injury that gets wrapped up in this complicated bankruptcy issue. But at the heart of it, these are some lawyers doing the everyday business of lawyering. And then they turn to ChatGPT. That's a lot better than some complex dispute where people don't come in knowing what it's all about.
So tell us about where you think ChatGPT will evolve to, since we're at this lawyer issue. Are they going to be able to get these cases right in the near future?
So I don't think ChatGPT is likely to be a good, reliable source for this in the near future. And I could be wrong about this. I think that we may see specialized legal search engines that have a high premium on reporting information about cases that people will turn to. And I'm going to be honest, some minimal generative AI features combined with a good database of legal materials will be a lot better than existing legal search in most ways.
What about, go ahead.
Just the ability to summarize cases that you have found in your search results will be incredibly helpful for lawyers trying to digest and understand bodies of law. As long as it is designed in a way that doesn't try to hallucinate case text and very clearly only quotes things that are actually present in the cases, which is, of course, where ChatGPT utterly fails, because that's not something that's part of its design brief at all. As long as it's built that way, it's going to be actually a pretty good tool.
Well, when you say built that way, people listening might say, wait, hang on, isn't the whole thing about these deep learning models that they are black boxes and the software engineers don't know how they actually work? They just know that there's going to be a result. How do you make sure that they're built in the way that you described?
So there are some architectural choices that you can make that can have very significant influences. And we don't, and again, I want to say these are all possible future developments. We don't have definite knowledge of how everything is going to go. But there are definitely models that are called retrieval models, which are designed to do their generation from a collection of sources that are provided to them. And so a retrieval model for searching case law would generate less original text and do more simply summarizing specific documents that it has found. And the AI search assistants that major companies are deploying now, so something like Claude from Anthropic or Sydney from Microsoft and OpenAI, they are really trying to get the model to do more in the way of finding and reporting on sources and less in the way of original synthesis.
Have you spent time thinking about how AI is going to change the way that we teach, the way that we research, basically our entire jobs in legal academia specifically, but academia more generally?
I've thought a bunch about this. The obvious starting point is, of course, tests. On the final exam of my internet law class this spring, I gave my students the questions, and then I had ChatGPT generate answers to them. And I provided the ChatGPT answers to my students, telling them, this is your baseline. You need to do better than it. But also, these are really bad answers. I hope after the semester in this class, you can do much better than these. I didn't tell them how the answers were bad, but I flagged they were bad, and they were. They're going to improve. I think the tools are going to get better to the point that will tempt students to use them. So we have a big conversation to go on about what the right way to deal with the fact that students have access to these tools is. And the students will use them to synthesize or summarize material from class. It may help with their understanding, it may hurt. We need to prepare for a world in which students are using these very extensively. Now, in terms of my own writing process and the research and work that I do, I have not found a way to integrate these tools yet. Now, Ethan Mollick, who is a business professor, has this great newsletter called One Useful Thing, which has talked a lot about using generative AI tools in your own work. And all of his advice is good about how you can use it to generate ideas and to vary on a topic. And I have not found a single thing he suggests that would fit into my workflow or approach. The quality of the text that I can get this way is just not at the level I want, I think writing should be. And the degree of confidence I have in what it does is just lower than I'm looking for. It won't save me time. It doesn't help me do the hard work of thinking through how to simplify something complex. I can honestly get the gist of an article about as fast as I can dipping into it than by asking ChatGPT to summarize it. I haven't found any edges yet. Maybe I'm just slow and stupid, and other people who are really digging into the tools and finding how to master them will become radically better scholars as a result. I can't rule that out. Somebody might find a way to be super good at understanding, synthesizing, and describing complex legal issues. That's possible. What I worry about more is that people will use this to fuel themselves in cranking out large volumes of mediocre scholarship. You'll be able to write 2 poor law review articles in a year instead of 1 decent one, and that productivity increase will seem to people like a good trade-off, when I think it's not.
So what about institutionally, in terms of whether it's thinking about what our roles as educators are in AI? You've talked a bit about how you generated answers for an exam and you use students' responses probably as a baseline to say you've got to do better than this. But in terms of the university as a whole, we're thinking about higher ed. How might we be able to leverage on AI more effectively than we are doing right now?
That's a hard question, and I don't know. And I think we have to be training students how to engage with these tools, understand their uses, and really understand their risks and limits. But I'm not at the moment prepared to do more than scratch the surface of that.
Okay. And that's probably comforting to, I think, a lot of our listeners who are afraid of being displaced by an algorithm. That doesn't sound like that's going to happen anytime soon. And they can pretty much go on what they've been used to doing, at least for another few years.
I don't know what we should be doing differently yet, but I think everybody should be thinking about that question. I mean, we should always be asking, are we doing our jobs as educators the best way that we can, and examining all aspects of our practice in light of that? This is just a particularly fruitful moment to be asking those questions.
Now, you have a dual appointment at the law school at Cornell Tech. Do you think that's the way of the future?
So it works really well for me, given the work that I do, because I am really trying to bridge computer science and law. And it's to be technical, it's not actually a dual appointment. I'm a law school professor on the Cornell Tech campus, and my 5 colleagues here who are computer science professors on the Cornell Tech campus. What makes this place unique is we just all sit in very close proximity, and we function as a single faculty here. I think for people in the law and tech space, this is a really good time to be building bridges to the technical fields that you work with. And that looks different at every place and every institution and for every scholar. Some people talking to computer scientists is a really important part of what they do. For others, it's going to people who are in the communications or science and technology studies department, people who are engaged with technology from a different social science or humanistic perspective. I don't know if this is the wave of the future for people in all legal disciplines. I think that there are absolutely fields that really benefit from close engagement with specific other disciplines. If you are doing environmental law, for example, environmental science is going to be an essential part of what you work with. But there's also a set of core sets of issues in law where the classic legal expertise in understanding how doctrine works and in how courts and legal actors apply legal rules to deal with specific matters, that's the heartland of our expertise. And there's still plenty of room for people who are good at that in some specific area of law. Like we need people who are really just continue to be contract scholars and know about particular kinds of consumer or corporate or other transactions.
Do you miss not being with the main corpus of your faculty at the law school?
So the pandemic helped enormously with this. Basically, it made everybody comfortable with Zoom. So I have a lot of contact with my colleagues who are located in Ithaca, and I honestly forget that I see them in person very rarely because I'm seeing them on Zoom so often.
From your own experience, and I think your experience is both a privileged one in a sense because you get that interaction with both your law school colleagues as well as colleagues elsewhere. Tell us about what from your experience worked and what didn't work.
So the Cornell Tech design, which was entered into very thoughtfully, was that the core relationship with your academic department had to be maintained. It's not a separate school, it's a separate campus. And that sense of shared mission and shared students and shared affiliation drives a lot of things that are successful. Cornell's done some very smart things to bridge the physical distance, and the fact that we've always had this bus that goes between New York City and Ithaca is, a good thing in keeping people unified and together. A lot of things that make a collaboration successful have very little to do with anything institutional and just have to do with having proximity to people who are working in other areas and talking to them. It takes a while to have these conversations, understand what they're working on, to really get at the areas where collaborations could work well.
And for law professors who are thinking of reaching across to the colleagues, you can talk about folks in the computing side. What were some of the challenges that you encountered early on and how did you overcome them?
So one of the obvious challenges is that the funding structures are extremely different. Law professors are salaried and we basically are paid to teach. We have students who are enrolled in degree programs to get typically a JD, sometimes a master's. The other fields have duties teaching undergrads and master's students. But when it comes to their research, they are running labs. They have teams, they have PhD students, and the cycles of that work and the support required for it are just extremely different. So part of what it took me a while to figure out was how to have effective joint projects when I'm sort of like an individual writing papers and they're a lab manager. It turned out the best solution for us here was for me to work with their graduate students. And sometimes this meant encouraging their students to sit in on one of my classes and take IP or internet law, and then become a kind of mini expert within their lab on some of the legal issues that affect them. And I talk to them and give them resources on, here's where you can read more, but now they have more of a legal perspective and the information flows to them. The other thing is that I started sitting on PhD committees, and that's really how the collaborations happen. You have a very smart and motivated PhD student who's developing a research agenda that's a mixture of technical with a bit of legal mixed in. And now I'm in a position to be on papers with them or to give them readings that are targeted very specifically to the legal implications of the technical issues they're working on.
And do these relationships continue after they have left Cornell Tech?
They do. I'm starting to accumulate a small family of people who I have collaborated with, who have gone out into other institutions. It's really quite nice. And it's also great to hear from them about how they're continuing this model in their own places, that they are often going to joint appointments, or they are producing papers that have some collaborative authorship across disciplines.
And do those relationships trickle upwards to their supervisors?
Absolutely. Once you have somebody in a lab who has that legal angle, I can just see the entire lab leveling up in their sensitivity to the legal issues, because they are talking to each other constantly. And so it just helps. They spot issues, they talk through the kinds of questions they raise, they put a paragraph in their paper that addresses it. And just sort of like, there are a bunch of my colleagues who are, they've always been interested in the legal issues, which is how I started talking to their students. But when you give them, it becomes a catalyst for the potential that they had within them all along.
Sort of like unlocking the force.
I guess so, yeah. That they've
Oh.
always been powerful, and they just not, and they know how to tap into it.
What about the law school students? Do they collaborate with the students there at Cornell Tech?
They do. So we have LLM students who are here for degrees in law, technology, and entrepreneurship. And that's a one-year specialized LLM. At Cornell Tech, they're sitting in classes with technical students. In addition to their core legal required courses, they have technical options that range from valuation of a company to applied machine learning. And so they are in there alongside technical and business students. They're also working on projects with these same students. We have a studio program where they are working in teams to solve concrete challenges or to start a company or do work on a public interest project. And that kind of direct technical collaboration is really, it's just great, because they come out of here, they're not going to go and take a programming job, but they are very confident in working with technologists.
And how much contact do you have with these students, these LLM students?
So these are the core audience that I am teaching in my courses. So these are the folks that I see in the fall in IP and in the spring in internet law. And so these are people I get to know very well over the course of the year.
They pretty much study at your feet.
Not quite. It's a very intensive program. So like I see them a lot, but the number of hours there in class, I'm only there for a small part of.
I want to talk about now communicating through mainstream media. You do a lot of op-eds and talking to folks in the real world through mainstream media. How did that come about, and how do more academics do what you do?
So in my case, I was always willing to pick up the phone when somebody called. I would say that two things happened that really made me really comfortable doing this role. One of them is that I had really good long-term relationships with several journalists. Just they called me on one thing, and I had a great conversation with them. And I thought this was they were very sharp. And a good journalist will probably talk to you for 20 minutes, and they might or might not use a quote from that. But they're doing a lot of research for this and really trying to understand it. The people who have been on a beat for a while are extremely good. So I just learned to take their calls and enjoy it. I'd learn as much from them as I told them. So those long-term relationships, there's certain authors who I quoted in a dozen of their pieces. The other thing is that the Google Books case, which I was following really closely, the lawsuit against Google for scanning millions of books and the attempted and then failed settlement of it, that was one issue that I dove into very deeply. And because of that, I was like one of the few experts in the legal academy who could speak to it. So I just turned into a regular go-to source for reporters on that beat. And that, that case is over. I don't get most of those calls anymore. But being a domain expert on something specific means that when that thing comes in the news, people from newspapers and websites will call you, and just really is just pick up the phone and spend some time talking to them.
What do you say to people who may be shy or nervous about speaking on the phone just because they're misquoted? They don't have really time to think about things on the fly, and they prefer responding via email.
So first of all, there are many reporters who are completely happy to get responses that way. I've done tons of press queries where I composed a paragraph and sent it back. And if you put your time into making it well-crafted and making sure that's quotable, they're happy with that. The other thing is that this is some interviews and not all, but there are reporters are trying to figure this out. And it is fine on the phone to hedge, say, no, I'm not sure about that, or to say, let's go off the record because I'm thinking out loud here, or to ask them questions to clarify. And reporters are friendly people. They spend all day talking to people. They are some of the easiest people in the world to make conversation with because they have a natural curiosity and just are really comfortable having conversations. So out of all of the work phone calls that you can take, reporter calls are some of the easiest and least stressful.
Yeah, something I should learn from. I think of this almost as channeling my inner reporter. But so in terms of your batting average for being quoted, are you more likely to be quoted with a well-crafted written response or a phone call? You don't know.
I don't know. It's just like not tracking my blog analytics. I don't really follow up on articles to see whether I was quoted.
So you just speak to them, you don't see whether you're quoted?
No, occasionally they'll send me a link to it, or some of my family say, hey, I saw you were quoted here. But I really find there are many areas of life and work where it's best not to look at your feedback. I
Oh, go ahead.
like I also deliberately post my articles. I post them to SSRN because everybody does, but I put a version on my own website and I always link to that one instead because I don't want to be driven by download counts.
And why not?
Because it's going to distort how I think of what I'm doing. I don't want to be tempted to write more on a topic just because it got downloaded a lot if I don't think that that's something that needs to be said the most.
Well, like your casebook, wouldn't that be like a market reaction to something that they liked or didn't like and therefore want to see more or less of?
It can be, but it can also be a quirk of, was it in one person's Twitter thread that went viral? If that's the case, that could easily double the download numbers on a paper. Like we're talking double digits here. So that's not meaningful signal. And oftentimes these numbers are indicative only in a very long run. Some of my early papers, they're papers on search and social networking, aren't great. They were just well timed. And so the historical number of downloads was more indicative of the fact they were early than they were good.
Well, do you get grief from your law school? They say, well, hey, you're putting out all that good stuff. We want to know. And so that we can put a link or a shout out that we have James Grimmelmann who's doing all this good work.
I mean, no, I tell them what I'm writing. I keep the communications office apprised of this, but I'm just not letting my own work be driven by the public perception.
And you leave it to them to, I suppose, track keyword searches for whenever James Grimmelmann appears on an article or some tweet.
Yeah, I would much rather know what my colleagues are publishing and be told about, hey, they have this new paper on X, than know how often they were quoted in major media. Like the work is more interesting than the publicity.
Where would you see quotes of being of most significance to you? When a court cites you, when Congress cites you, mainstream media, fellow academics, what's most meaningful for you?
So what was most personally meaningful for me, I think, was when, during the Google Books case, when I got quoted in Publishers Weekly a lot, just because that was a magazine that my family got when I was growing up, because stepdad's really into books. And so he wanted to know what was coming out. And so he's not in the industry, I'm just subscribed to it. But when the magazine that came every week to your house as a kid quotes you, that means a lot. That's a personally meaningful connection. So I really liked that. Beyond that, the things that I really like the most, wherever, regardless of where they are when it's clear that somebody read it or engaged with what I had to say and thoughtfully and found it useful to them. So I have had really great experiences being cited in lawyers' briefs. When a lawyer says, yeah, I think this theory in your article is pretty persuasive, I'm going to try to advance this in court. And they say they win the case on other grounds. Like, doesn't reach what I did at all. The court didn't mention it, but the fact that the lawyer found my thinking helpful is really meaningful to me. And that kind of validation could come pretty much irrelevant of the medium. It's, did you connect with somebody who learned from what you did?
And do some of these connections translate into consulting opportunities?
I don't do much consulting. I will, I'll do speaking engagements. I've done things where I'll go and talk to a group, but I, for the most part, haven't done consulting.
And why is that? A lot of people will say, hey, one, the people that are driven by the financial incentive because they pay well. The other would be, well, I'm actually influencing a real ongoing case in a direct way. Neither of these appeal to you?
Those are obviously appealing motives, but I set them against my limited time, and it's not necessarily as fulfilling as working on another project. And I also really value my independence. So I think really hard before agreeing to anything that might create a conflict of interest. And especially litigation consulting, would be the kind of thing where I really want to be free to take positions that seem correct to me without having clients whose interests I need to consider. Like,
Have you
enough of a lawyer to know that like that legal obligation is not one to take on lightly.
had to reject funding?
So funding is different. To me, the major principle there is to be transparent about where funding is coming from and to be scrupulous about the funding not influencing the content of the work. So I took Microsoft money during the Google Books case to put on a couple of conferences about the case. And that's what funded the website we did to educate the public. I caught a lot of grief for that. I still think that the work product we did speaks for itself in being high quality, neutral, and not influenced that way. But that was absolutely a thing that I thought hard about in terms of what do I need to do to make sure that the source of funding doesn't compromise my judgment.
Do you think the grief you got was a result of a directed campaign against the credibility of the website, or just lazy thinking or something else?
It was absolutely directed. Google went after me for that as a deliberate tactic. And the funny thing is, it was clearly one part of Google that, like in their public relations group, was trying to portray this as an organized campaign by Microsoft against them. The engineers and managers working directly with the book's project knew that I was not out to get them. They maintained good relationships with me the whole time. I learned immense amount from them, and we disagreed on a lot of things, but we had very respectful dialogue. It was just the other part of Google's shop decided this was an opportunity to score points against Microsoft.
And did this shop know what the other shop was doing?
To this day, I do not know.
So, a couple more questions to wrap up. One is, this is just an opportunity to invite you to think about your own growth as a leader. Who are your mentors?
So I learned an immense amount from some people who influenced me during my young academichood. Lawrence Lessig, not as a direct one-on-one mentor, but as a symbol of what somebody with principles and a good vision for change can do, was incredibly influential on my desire to be a law professor at all and to take openness incredibly seriously. And then Beth Novak, who was at New York Law School and really was my mentor when I started there, also had a huge influence. Now, we do extremely different styles of work because she's been so involved with policy and with building tangible products for most of her career. But I learned an immense amount from her about convening people and about what a good research environment looks like and about how to keep up one's energy and excitement about the work every day. Like just a really, really positive vision of somebody living their best life as a law professor.
Yeah, and what does mentoring look like to you as a mentor?
So at this point, I'm basically trying to be there for my students and my postdocs when they are like learning how to do this thing. And that is modeling patience, modeling dedication and care about what we're doing, and about really making sure that they are in a sustainable, healthy place as people who will want to be doing this long term. Like, care a lot about what you're doing because it's interesting, because it's good for the world, and make sure that you yourself are behaving well and taking care of yourself as you get there. Everything else can come after that. If you take care of those things, that's the fundamentals.
Yeah, so one of the things that you do and many people share with you is your time at the ISP at Yale. Is that something that you would be interested in creating at Cornell?
So I deeply admire the Yale ISP. Jack Balkin is another one of mentors that had a huge influence in my life. And Jack's attitude towards scholarship and his attitude towards mentoring the people who are working with him are really good. I think the ISP is a really healthy place, and it produces people who are curious and who care about the craft of research and scholarship. It's also not an institution that I think I could build or run. There's a structure to the ISP, and it's got a very wide tent of interests, and it's very much a Jack Balkin production that reflects his style. And I admire it. I love it. I could not do that successfully.
Not running ISP, but creating something at Cornell that reflects your vision, but doing things that may be similar to what ISP is doing.
Yeah, it's like it's taken me 15 years in the profession to understand what that kind of a thing looks like. And I'm trying to create that now. And that's essentially, the formal name is Control-Alt, the Cornell Tech Research Lab for Applied Law and Technology. And it's essentially a research lab in the sense that science professors have research labs. People who have a shared set of interests working broadly on projects in those areas together. The broad ambit is law and computer science. And so this is a really good chance to work with a really sharp group of graduate students, postdocs, and fellow faculty who are interested in these things together. And mostly we just sit around and talk about what's been happening and what we think about it and what we could write to explain it better to the world.
And if folks listening to this outside of the Cornell environment want to be part of it, can they?
So Control-Alt is kind of small and like it doesn't have too much of an external presence. But the unit that we're part of, the Digital Life Initiative, is big enough to support a lot of interesting public programming. So Helen Nissenbaum runs the DLI, and it has a wonderful speaker series every Thursday lunchtime. There's an outside speaker talking about technology, ethics, policy, law, quality of life. And that speaker series is open to the public and is a great way to be part of the community at Cornell working on these things, of which law is a very significant part.
Thanks. Last question, and last word goes to you, James. 2023 and beyond, what should folks expect from James Grimmelmann?
So I keep on saying this, and someday it will become true, but I would like to wrap up all of the papers that I'm working on and just write books. I want to write the book I'm working on about law and computer science and what the role of interpretation, both by programs and by judges. And then I've got a whole string of ideas for things that I want to do after that, including like redescribing how we do all of intellectual property law to recategorize and reorganize it. And I got plenty more after that. I just need to clear my decks of all this other stuff first.
That sounds exciting. This has been such a treat, James. Thank you for taking the time to speak with me, and all the best for those future endeavors.
Thank you. It's been a great pleasure.